It was required in 58 because of a constitution of Jammu and Kashmir being framed and constituent assembly ceasing to exist, and because of the state reorganization ceasing to exist, and because of the state reorganization bottom, D is deleted. At page 67, reference to the legislature or the legislative assembly of the said state shall be construed as including reference to the constituent assembly of the said state. Because the constitution was framed, constituent assembly ceased to exist. Because the constitution was framed, clause was amended. And E, and therefore, my lord, this clause was amended. Raj Pramukh and E was replaced. The term Raj Pramukh, governor, was because of the state reorganization. By the word, now Raj Pramukh system has gone. Because of the state reorganization. Now Raj Pramukh system has gone.
Yes.
Phraseology used was governor henceforth from this.
Yes, henceforth it was governor.
Yes.
But the phraseology used governor to head of the elected government as prime minister did not cease with this. But the phraseology used to head of the elected government as prime minister used to be called the prime minister there.
Yeah, that went, my lord, after Sadre Riyasat.
Minister used to be called the prime minister.
It became Sadre Riyasat. That went, my lord, after Sadre Riyasat.
After that.
It became Sadre Riyasat. Prime minister went. Yes, yes.
After that.
It became Sadre Riyasat, and thereafter, my lord, Raj Pramukh, and thereafter it became Sadre Riyasat. Now it remains governor throughout thereafter. Governor. Now kindly see, my lord, it remains governor throughout thereafter. I am skipping the rest, my lord. Now, they are, my lord, page 69. I am skipping the rest, my lord. They are, my lord, kindly see, my lord, first page 68. Premnath call, but the first judgment. It was more on the competence of the first Yuvraj. It was more on the competence of may not render us.
Can we just read that para?
And therefore, my lord, I'll, my lord, please. The Supreme Court renders its judgment in Premnath Kaul versus State of Jammu and Kashmir. It's a 5-judge bench, my lord. The issue before the court was the validity of Jammu and Kashmir Big Landed Estate Abolition Act, which was enacted by the Yuvraj in exercise of powers vested in him under Section 5 of Jammu and Kashmir Constitution Act, 1996. Well, 1996 is somewhat here, 1939, the old constitution. The judgment discusses the constitutional history of the state in great detail and at the same time discusses the power of Maharaja under the previous constitution of the princely state. The question before the court was whether the provision of Article 370, Sub-Article 1 till the time the Constituent Assembly of Jammu and Kashmir was in session affect the plenary powers of Maharaja in the matter of governance of the state. In this context, the court held that the act in question, which was enacted in 1950, would not stand interdicted by Article 370 and held that Yuvraj was competent to enact the act. The case effectively concerned the issue of legislative competence of Yuvraj when there is no Constituent Assembly of Jammu and Kashmir. Yes. But in these very proceedings, when there was a request for a reference to a larger bench, in this very petition, Lord, the 5-judge bench, Lord, speaking through my Lord Justice Call, exactly said this, that it may not have bearing on the either side. Now, Lord, page 69. Now, my Lord, the integration of judiciary. Slowly, my Lord, some provisions came to be applied, truncated, some full, some modified, some with exceptions. But Article 222 was made applicable regarding transfer of judges. Earlier, my Lord, till 60, the honorable judges of the High Court were not transferable by the Supreme Court. But the oath was prescribed, and till 2019, the honorable judges of Jammu and Kashmir High Court used to subscribe to this oath. Please see. Oath or affirmation to be made by judges of the High Court I, Sri So-and-so, having been appointed Chief Justice or a judge of the High Court of Jammu and Kashmir, do swear in the name of God, solemnly affirm that I will bear true faith and allegiance to the Constitution of the state. Though they were, my lord, under an obligation because of Article 1, and they were applying the Constitution of India. But the oath which they used to take was expressing their allegiance to the Constitution of Jammu and Kashmir state. Even the Honorable Chief Justices, my lord, who would be appointed there, would be taking this oath. That's it, my lord, nothing beyond. Now, your lordships may kindly come to Puranlal Lakhanpal judgment, my lord, where I would read only one para, my lord, of that judgment, because something turns on that, and I will show, my lord, Sampat Prakash thereafter, my lord. At this stage only, my lord. Please come to, my lord, Case Law Compilation, Volume 1. Page 24, my lord. Only para. Kindly see, my lord, in those days, what used to...
Which one did you say?
I'm sorry,
Volume 1.
Case Law Compilation, Volume 1, PDF page 24. Well, somebody wanted to stand for election to be elected to the House of People, that is Lok Sabha. He filed this petition. Please see, my lord, page 1 and 4. My lord, only 2 would be relevant, my lord. Am I with your lordships on page 5? My lord, 24? Premnath Kaul, my lord. The petition challenges the constitutionality of a provision in the Constitution Order 54 made by the President under Article 371. The case of the petitioner is that he is registered as an elector in the parliamentary constituency of Delhi. As such, he has a right to stand for election from any parliamentary constituency in India. 6 seats are allotted to the state of Jammu and Kashmir in the House of People, Lok Sabha. Ordinarily, the election to these seats should have been direct election from the territorial constituencies in the states as provided by Article 81(1). And this is what was happening in rest of the country. But the President modified that article insofar as it relates to the state of Jammu and Kashmir by para 5C of the order in these words. Article 81 shall apply subject to the modification that the representatives of the state in the House of People shall be appointed by the President on the recommendation of legislature of the state. No direct election in Lok Sabha. It's like Rajya Sabha. And the contention was, the petitioner contends that the President had exceeded his powers when he made this modification, for he thereby substituted direct election to the House of People by nomination which he could not do. This, it is said, was a radical alteration. But please mark these words.
Yes.
Yes. Now, kindly, my lord, come to para 4. The court says even radical modification is permissible. But even assuming that the introduction of indirect election by this, my lord, your lordships have para 4, my lord, at page 25. May I read with your lordship's permission? But even assuming that the introduction of indirect election by this modification is a radical alteration of provisions of Article 81(1), the question still remains whether such a modification is justified by the word modification as used in Article 371. We are hereby dealing with the provision of a constitution which cannot be interpreted in any narrow or pedantic sense. The question that came for consideration in Delhi Law's case was with respect to power of delegation to a subordinate authority in making subordinate legislation. It was in that context that the observations were made that the intention of the law there under consideration when it used the word modification was that central government would extend certain laws to Part C states without any radical alteration in them. But now this is the ratio. But in the present case, we have to find out the meaning of the word modification used in Article 370 sub-article 1 in the context of the Constitution. As we have said already, the object behind enacting Article 370 sub-article 1 was to recognize the special status of state of Jammu and Kashmir and to provide for that special provision by giving power to the President to apply the provision of the Constitution to that state with such exceptions and modifications as the President might by order specify. We have already pointed out that the power to make exceptions implies that the President can provide that a particular provision of the Constitution would not apply to that state. If therefore the power is given to the President to efface in effect any provision of the Constitution altogether in its application to the state of Jammu and Kashmir, it seems that when he is also given the power to make modifications, please note, my lord, mark, that power should be considered in its widest possible amplitude. If he could efface a particular provision of the Constitution altogether in its application to the state of Jammu and Kashmir, we see no reason to think that Constitution did not intend that he should have the power to amend a particular provision in its application to the state of Jammu and Kashmir. It seems to us that when Constitution used the word modification in Article 371, the intention was that the President would have the power to amend the provisions of the Constitution if he so thought fit in their application to the state of Jammu and Kashmir. But thereafter, dictionary meanings, etc., is quoted. Lord, why I am reading this? Lord, Mr. Nafde urged that this is an obiter and therefore not laying down any law. Lord, in Sampat Prakash, subsequent judgment, again, my lord, the same Lord, numerical strength, 5 honorable judges, reproduces this para, relies upon it as a ratio. It's not an obiter. Lord, let me directly go to Sampat Prakash so that this point is clear. This is not an obiter. This question directly fell for consideration. The petitioner wanted this honorable court to interpret whether there is any power of radical alteration or modification. And this honorable court said, you can even efface a part of the Constitution. Then obviously radical alteration is something which you can do. Now, Lord, in the same compilation, if your lordships can come, the next judgment, my lord.
27.
Yes, my lord. Please come to, my lord, page 27. This was a detention case. Please come to para 2. At page 28. Does your lordship not have them? I'll just read para 2. During the preliminary hearing of this petition, Mr. Ramamurthy, representing the petitioner, it was, my lord, a detention case, raised the ground that section 13A of the act, under which, my lord, the local act, under which the petitioner was detained, was ultra vires the Constitution as contravening the provisions of Article 22 of the Constitution. That question was referred by the Constitution bench to the court to a larger bench and came before the full court. On this occasion, the court held that in view of clause C of Article 35 of the Constitution introduced in the Constitution in its application to the state of Jammu and Kashmir, the point that had been raised stood answered by the addition of this clause, and unless the clause itself was challenged, the point raised on behalf of the detainee did not arise. In this view, the reference was dissolved and the case has been heard by the Constitution bench. They said that till you challenge 35C, obviously fundamental rights under 21, 22 are not applicable to a detainee. My Lord, thereafter, my Lord, your Lordships may kindly come to page 29. Look, this takes care of Mr. Dwivedi's argument. Mr. Dwivedi for the petitioner. No, but on this side also we have Dwivedi.
You have to argue anything.
Yes.
That's in a brotherly sense.
Yes, sir. 29. The first argument, my Lord, your Lordships would find after, my Lord, quotation of the section. The first argument was that this article contained temporary provisions which ceased to be effective after the Constituent Assembly convened for the purpose of framing the Constitution of Jammu and Kashmir state had completed its task by framing the Constitution for that state. Reliance was placed on the historical background in which this Article 370 was included in the Constitution to urge that the powers under this article were intended to be conferred only for the limited purpose and limited period until the Constitution of the state was framed, and the President could not resort to them after the Constituent Assembly had completed its work by framing the Constitution of the state. The background or the legislative history to which reference was made was brought to our notice, my Lord, that your Lordships can, my Lord, skip. Then your Lordships may kindly see para 5, my Lord. My Lord, your Lordships can, my Lord, directly come to 7, my Lord. There are, my Lord, your Lordship gets, my Lord, at page 30, at the foot, para 7. There are, may I read? There are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after the Constituent Assembly of the state has passed the Constitution of the state. The most important provision in this connection is that contained in clause 3 of the article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as the President may specify by public notification, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. This clause clearly envisages that the article will continue to be operative and can cease to be operative only if, on the recommendation of the Constituent Assembly of the state, the President makes a direction to that effect. In fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by the President declaring that article shall cease to be operative. Both things are separately mentioned. Neither recommendation made nor President exercised, meaning thereby the President could have exercised the powers even in absence of a recommendation, since there is no Constituent Assembly. I hope, Lord, I am able to make myself clear that till Constituent Assembly was in existence, recommendation. Even otherwise, President could have done it after the Constituent Assembly ceased to exist. On the contrary, it appears that the Constituent Assembly of the state made a recommendation that the article should be operative with one modification to be incorporated in the explanation to clause 1 of the article. This modification in so and so. My Lord, thereafter, kindly come to the real issue, my Lord, that is 14. There are 13, my Lord.
13 or 14?
13, my Lord, first. The next point urged was that Article 368 of the Constitution having been applied to Jammu and Kashmir with a proviso added to it, there now exists a provision relating to amendment of the Constitution as applied to Jammu and Kashmir under this article, and consequently, while such special provision for this purpose exists, we should interpret Article 370 as being no longer applicable for amending or modifying the provisions of the Constitution applied to that state. This is what was argued by Mr. Nafde. Now, please see what your lordships say. Para 14. I'm sorry, I'll read it for you. This argument, in our opinion, is based on a wrong premise. Article 368 has been applied to Jammu and Kashmir primarily with the object that amendments made by Parliament in the Constitution of India, as applicable in the whole of the country, should also take effect in the state of Jammu and Kashmir. The proviso, when applying this article, serves the purpose that those amendments made should be made applicable to the state of Jammu and Kashmir only with the concurrence of the state government, and after such concurrence is available, these amendments should take effect when an order is made under Article 370 of the Constitution. Thus, Article 368 is not primarily intended for amending the Constitution as applicable to Jammu and Kashmir, but is for the purpose of carrying the amendments made in the Constitution for the rest of India into the Constitution as applied in the state of Jammu and Kashmir. Even in this process, the powers of the President under Article 370 have to be exercised, and consequently, it cannot be held that applicability of this article, that is 368, would necessarily curtail the power of the President under Article 370. It was also urged that the power of making modifications and exceptions in the orders made under Article 371D should at least be limited to making minor alterations and should not cover the power to practically abrogate an article of the Constitution applied in that state. The submission is clearly without force. The challenge to the validity of Article 35C introduced in the Constitution as applied to the Jammu and Kashmir on this ground was repelled by this court in P.N. Lakhanpal versus State of Jammu and Kashmir. Subsequently, the scope of the powers of making exceptions and modifications was examined in greater detail by this court in Puranlal Lakhanpal.
Yes.
And that is, my lord, which I read, para 4, which as per Mr. Nafde was a mere obiter, but the subsequent bench treats it as a ratio, relies upon it, and holds the same thing. But please come to, my lord, now just before one line before paragraph 15. I'm sorry. Para, page 34, just above para 15. This decision, your lordship gets, how the subsequent 5-judge bench treats Puranlal Lakhanpal, para 4 of Puranlal Lakhanpal, which, my lord, Mr. Nafde contended is a obiter. This decision being binding on us, it is not possible to accept the submission urged by the council. So Puranlal Lakhanpal, para 4 is treated as a ratio. Then 15. Yes. May not be of relevance. I'll just come back to my written submissions again. That's on the facts. The rest is on the facts of the case. Lord, please come to page 70. Here, parliamentary supremacy.
70 of your submissions.
My submissions, that would be combined submission, okay. Volume 3. (246) was applied. with some modification, of course. Lord, CO 66, Article 246, which was originally applied in 1954 with only one clause, was applied with modification that Parliament would have the power to make laws in the Union list and some entries in the concurrent list applicable to Jammu and Kashmir. Article 254 was applied in toto, thereby ensuring supremacy of the parliamentary laws in case of repugnancy. Lord, rest, there are some additions, my lord, which may not be of much assistance, my lord. Kindly come to page 71. Once again, the Lok Sabha, my lord, takes up this issue. And where, my lord, those famous words of the Honorable Prime Minister Nehruji, my lord, are reproduced. Only underlined portion. As a matter of fact, as the Home Minister has pointed out, it has been eroded, if I may use the word, and many things have been done in the last few years which have made the relationship of Kashmir with the Union of India very close. There is no doubt that Kashmir is fully integrated. I repeat that it is fully integrated. The provision eroded. Most of the provisions are applied according to the situation of the day, and it was awaiting of being extinguished right from 64 onwards. Then, my lord, page 72, CO 69, my lord, this provisions of Article 19, subclause 7 was added, and 35C were extended from 10 years to 15 years. My lord, as I have pointed out, my lord, it came to be kept on being extended till 74. Now, my lord, a private member's bill comes before the Parliament for abrogation of Article 370. Please see, my lord, the debate, the underlined portion only, my lord, for brevity, my lord, so that I don't, my lord, waste more time of your lordships. Inder Malhotra, nominated from Jammu and Kashmir, says this: the people of the state have no special liking for this Article 370, which exists in the Constitution, and we shall be very happy as soon as this is omitted. This was the debate, whether it should be omitted, it should be abrogated, etc. Then Hari Vishnu Kamath, he was also a member of the Constituent Assembly of India. A very leading member, one of the members who contributed immensely. That accession is irrevocable and that integration must come very speedily. If that is accepted, then there cannot be two opinions on the question. That article must go. I take my stand so far as this article is concerned on the firm base that now Jammu and Kashmir state is suffering because this article is there, because difficulties are there by created. If this article is repealed, the state will derive some benefits as other states of the Union are deriving from their relationship with the Indian Union. And therefore, it is from that point of view, that Jammu and Kashmir should be as much a beneficiary of the relationship with the Indian Union as every other state, such as Mysore or Kerala or Bengal or Maharashtra or Madhya Pradesh is today. But, and unfortunately today, Jammu and Kashmir is not a beneficiary of this relationship in the same way and to the same extent as other states. Then, my lord, Shamlal Saraf, my lord, adds, retaining Article 370 by not bringing the state at par with the states in the rest of the country. What has been happening? Firstly, there is a sort of insecurity in the minds of the people. Secondly, I will say this frankly, in certain cases, local vested interest, some of them may have been my colleagues, want to have the best of everything and want to take advantage of the present situation. Without bringing any communal, sectarian, or any other view into the matter, I will say that purely from the people's point of view, the people of state have suffered. Once these barriers are removed, once they are allowed to function as any other part of the country, the people will very much benefit. But what was barrier for the people was being canvassed and people were being convinced as a privilege to fight for. Then, my lord, Sri Sonavane in the chair. My lord was from Jammu and Kashmir, my lord, in the parliament. Then, my lord, Sri Sonavane in the chair, underlined portion. There is the non-application of labor laws. In my state, there are lakhs of people working in various forests, handicrafts and factories, and all the beneficial laws that we have in the center and which are applicable to the rest of the states, as Nandaji knows, as ex-labor minister, that is Gulzarilal Nanda, my lord, became acting prime minister twice, labor minister, should ipso facto apply to that state also. I have myself been a small labor worker, and as a minister, I was in charge of labor also, and I know the feeling of workers in that state. Every time they say, why do you keep this wall of separation? Let us all get tile benefit as the rest of our countrymen. After all, in labor, where people work, there is no question of caste, color, or religion. Therefore, it is equally important, and I would say forcefully, that these things should apply there also. Then, my lord, D.C. Sharma, my honorable friend Sri Gopal Dutt Mengi has said that Article 370 is a wall. I would say it is not a wall. If it was a wall, I could demolish the wall easily and in no time. It is not a wall, but it is a big mountain which stands between India and Jammu Kashmir. Although we have dug the Bani Hal tunnel and we have done everything else, we have not demolished the mountain yet. I feel this mountain should be blasted with dynamite, with the dynamite of goodwill, firmness, and decision. That way lies the salvation of India, and that way lies the good and welfare of the people of Kashmir. Then, my lord, at the foot of this page, my lord, in the debate, Sri Abdul Ghani Goni, the people of Kashmir had decided once and for all, and have decided once and for all, that Kashmir is an integral part of India. Whether there is Article 370 or no Article 370, it is only a provisional provision and a temporary provision in the Constitution which can be removed at any time. But as far as the complete accession is concerned, that is final and nobody can challenge it. Then, my lord, Mansingh Patel on the next page, 76. I am skipping the rest. Lord, Mr. Ghoni, my lord, I am told, was also a member of Constituent Assembly of Jammu and Kashmir. And thereafter, he was a minister also. Then, my lord, Mansingh Patel, we have said before the world as a whole that there is no possibility now of plebiscite, and the integration of Kashmir is firm, final, and irrevocable. We continue with this Article 370, thereby showing to the world as if there is still some difference between Jammu and Kashmir and other states of the Indian Union. This kind of maintenance of separate identity of a state creates difficulty for us. Chatterjee, my lord, I am not reading, voices the same sentiment. Please come to, my lord, page 77, Sri S.S. More, only highlighted part. I'm sorry, my learned friend wants me to.
Minister, very interestingly, Mr. Chatterjee refers to the statement of Mr. Sadek, who was the...
Yes, my lord, I'm sorry, my lord, I would, my lord, rather read that.
Vice President
I have,
of National Conference. Vice President of National Conference.
yes, my lord. I have in my extra hand an extract from Hindustan Times dated so-and-so, which reads thus: the veteran founder Titor and National Conference leader Mr. Sadiq today confirmed reports of lawlessness and corruption in the administration of Jammu and Kashmir. Mr. Sadiq, I'm told, was the Honorable Chief Minister then.
He took over after Bakshi Gulab.
Yes, madam. Mr. Sadiq, who is the senior vice president of the ruling National Conference, declared in an interview that abrogation of Article 370 of the Constitution was essential for the restoration of normalcy in that state. I maintain that it is today more imperative for the restoration of normal conditions, for the upkeep of democratic life of that state, and for greater cohesion, both of the people of Kashmir and India as a whole. We should not delay any further. What has happened since 29th of November 63 till today, which necessitates that there should be any going back on the solemn declaration that Article 370 must be abrogated and it is essential for restoration of normal conditions in that state. What is heading of this chapter, that chapter? It is in part 21 of the Constitution, temporary and transitional. Therefore, Article 370 was never 77, the last four lines of N.C. Chatterjee, Manoj. Therefore,
Yes.
therefore, in the very content of this article, there is a clear demarcation, a clear expression of the will of the makers of the Constitution that it shall not be permanent feature, and the President, by a declaration, by a notification, can say that this article shall cease to operate. Lord, why I am reading this, the argument of the petitioner was that once the Constituent Assembly of Jammu and Kashmir is dissolved without recommending anything, it became permanent. I am just pointing out that subsequently also two things are happening. Everyone says it is temporary and everyone expresses the desire. Why is it not being now?
These are views, really. These
Correct.
are views on the floor of the.
But, my lord, please see Mr. More's view. He has articulated, my lord, beautifully on that very page. Next, I rise to accord my hearty support to the present bill. I have read article. I'm sorry, they are views. This is how Parliament understood it.
Not
That's-
Parliament, an individual member of Parliament.
My lord, this is how, my lord, nobody disputes that no, it is permanent.
It was not the view of the government of India, at least, because they would have done it then.
No, our my lord, law minister has said, the honorable prime minister has said.
These are individual views which.
What happened to the bill? But
Private member bill.
It was a private.
The private member bill, it's not carried.
what he is reading, Mr. Subban, is the sentiment running across.
But Manoj, when you read the whole debate, Manoj, he's only given you parts. The whole debate is.
There will be debates in favor, there will be debates against.
That's what I'm so.
Ultimately, Mr. Solicitor, we have to construe the constitution. We can't really, these are not really expressions of view by Parliament as a collective body.
This is
Right,
how, my
individual
lord, it
member
was
says
understood.
something.
That's all. I leave it at that. Now, my lord, kindly see the view of the government at page 78 bottom. 4th December 1964. In continuation of the debates mentioned above in a speech, then Home Minister Gulzarilal Nanda reaffirmed the temporary nature of Article 370. This is the view of the government. There is no wall between Jammu and Kashmir and India. At the most, you can say it is some kind of a movable partition. We can move it on our own. There is nothing coming in the way. This is the view of the government also. I take this opportunity to inform the House that it has been decided to apply the provisions of Article 356 and 357 also to Jammu and Kashmir. Entry 43 and 78 of the Union list and 33 and 34 of the concurrent list are also being made applicable. I skip a lot, then the highlighted part. Therefore, the area of uniformity is being constantly extended and it is being accelerated and expedited. And as I said before, the House would certainly understand from what I have said that anything else which has to be done quickly could certainly be considered and some kind of action could be taken on that. The government assures the Parliament. Then Hembara, when you have done so much, why don't you do the rest? Sri Nanda, those who have done so much will certainly do the rest.
The concurrent list was made applicable with, of course, modifications by CO 66, right? Just for the sake of CO 66.
For the first time, yes, my lord.
That is 26th of September 1963, right?
My lord, sir. Now comes, my lord, third instance of mechanism under Article 367, page 80, my lord.
The substitution, that is what I was asking for a fact only, Mr. Solicitor.
Yes,
It's
my lord.
only in 1965 that the expression Prime Minister changes to Chief Minister. Your list of dates of 10/4/1965.
No, my lord, Prime Minister description went long back.
Please
Sadr Riyasat was changed.
Please read 10/4/1965.
No, your lordships are at page.
Your notes.
Your note.
Oh,
reads
okay, well, your lordships are right. Your lordships are right. Though this act, the expression Sadr Riyasat and Prime Minister in the state's constitution were to respectively be, your lordships are right. It was
I had an impression, I was not sure, that both things occurred.
in the constitution of Jammu and Kashmir.
Kashmir occurred simultaneously.
Your lordships are right. I stand corrected. I was, my lord, answering the Constitution of India point of view when it changed, my lord, in 367. But your lordships are right. In in the Constitution of Jammu and Kashmir, Lord, it was simultaneous in 65. Then, my lord, CO 74. So that is page 80. Lord, please see at the foot what changes were made. Lord, CO 367 was the mechanism of Article 367 of the Constitution was amended so as to give effect to Article 370. Please see, my lord, AA, this is addition in green. The lordship gets, my lord. References to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadr-e-Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. References to the government of the said state shall be construed as including references to the Governor of Jammu and Kashmir acting on the advice of his Council of Ministers, provided that in respect of any period prior to 10th day of April 55, such references shall be construed as including references to Sadr-e-Riyasat. Then E was already deleted. E was already deleted. I have just kept it here, my lord, as a record for continuance. It was not deleted by this CO. It was earlier deleted, which I have already shown to your lordships. Lord, this change was the subject matter of Muhammad Maqbul Damnu, this particular CO. Lord, I'll have to read some paragraphs of Damnu, my lord. Can I do it after the lunch break, my lord? It's now a few minutes.
Just as an aside, Malad, during these debates, Malad, Pandit Jawaharlal Nehru intervened and he said, if you talk about outsiders buying land in Jammu Kashmir, I am totally opposed to it because big business will come in, Malad, and will destroy the entire state completely. So he was very adamant on that.
That was a mistake, my lord.
I'm sure it was a mistake. I'm only saying those
that
parts,
was
those
my
parts should also
understanding
be
is
read. Those parts, I'm not saying
that, my lord.
everything that we did was always a mistake.
No, I'm not being political, my lord. I'm from citizens' point of view. Unless investment comes, you never develop.
Why it did not culminate into something?